Welcome to All Things Work, a podcast from SHRM. I'm your host, Anne Sparaco. Each week on All Things Work, we dive into game-changing trends transforming the world of work and the workplace. And this week, we're breaking down the complex nuances surrounding the coordination of leave. And we have an expert here today just on that very topic. Joining me today is Robin Shea, a distinguished attorney at Constangy, Brooks, Smith, and Prophete. Robin, welcome to All Things Work. Thank you for joining us.
Thank you very much, Anne. Appreciate your having me.
So, Robin, you have an extensive background in employment law. You have a lot of experience. Let's start things off by talking about, what really brought you to specialize in this area of law?
That's a great question. I'm bad at math, so that's probably the real reason. But I do kind of enjoy people problems, and I think employment law gives me a lot of opportunity to deal with those. So I think that's really what it is. I'd probably have gone into HR if I hadn't been a lawyer.
And employment law, it covers so much, a lot of complex topics as well. And it dives into the American Disabilities Act and the Family and Medical Leave Act. I just saw on your LinkedIn, you have a blog recently about the FMLA, discussing, certain stories regarding that. And we know there are distinct differences between these two laws. And not everybody may quite fully understand those differences. But can you explain how those differences impact the management of leave policies within an organization?
The FMLA is very, very specific. You have to work a certain period of time before you qualify for leave. There are certain specific designated reasons for approved leave. Some of them have to do with the employee's own medical conditions. Some of them don't. And some of them are not related to medical conditions at all, like qualifying exigency leave, which relates to military service. So it's a very specific, precise law. There are precise regulations issued by the U.S. Department of Labor. It's specific required written notices that have to be given at various stages of the leave. Well, the ADA is almost the opposite of that. The ADA is very loosey-goosey, and it's enforced by the EEOC, the Equal Employment Opportunity Commission, rather than the Department of Labor. And the attitude under the Americans with Disabilities Act is, whatever works is okay with us. There are no minimum periods of service required before you're entitled to a reasonable accommodation under the ADA, which could include leave as one of many types of accommodations. And, basically whatever the employer and the employee are satisfied with is going to be okay.
I like how you did the juxtaposition, a little more formal and a little more loosey-goosey. It's a good way to put it, for people to just kind of get a general understanding of the real differences between the two.
Yeah, they are very different. And it's kind of bad in a way because they overlap so much, depending on the reason the employee needs the leave. And an employer may have to comply with both of them, and they're so different.
Like, as we mentioned, a lot of nuances, a lot of complexities there. That's why, people like you are so important to really, dive into this type of knowledge, to really just help people out and help employers understand which direction to take in either scenario, especially because each employee has such specific needs that could fall under either or, right?
Right. Or both at the same time.
Exactly.
And to complicate it even more, we now have the Pregnant Workers Fairness Act, which requires employers to accommodate pregnancy and pregnancy-related conditions. And that could also include leave as a possible reasonable accommodation related to pregnancy. So it's just one thing after another. And then on top of that, we have numerous state laws governing leave. And those generally apply based on where the employee works, not where the company is headquartered.
Right.
And so employers may have to worry about, 20 different state laws on top of these three big federal laws. And with the expansion of working from home since COVID-19, that means employers may have employees in all 50 states, and there may be multiple state leave laws. Generally, they're more liberal than the federal laws about the types of leave. Many of them require paid leave, which we don't have yet under federal laws. And an employer may have to keep up with all of those laws, depending on which employee requests leave.
And it can leave some HR professionals almost between a rock and a hard place of what to do, right?
Yeah, yeah, it's tough. Some clients I have decided, we're in multiple states. We're just going to take the most strict law that applies to anybody, and we'll just follow that for everybody. And
Right.
that's one possible solution. At least it gives you some consistency. The
Yeah.
downside is you may be doing a lot more than you actually have to do in a lot of jurisdictions, depending on where
Mhm.
you are.
Are there other types of solutions that may work or help alleviate some of the problems there?
Well, it's not much of a solution, but yeah, a lot of employers just decide we're going to follow the applicable law where
Okay.
the employee is.
Mhm.
And that can generate a lot in legal fees because they may have to be consulting a lot more if they're trying to issue a handbook. A handbook used to be a real quickie job. And now, if you have an employer in multi states who is
Mhm.
trying to have separate leave policies for all the jurisdictions that's compliant with all the jurisdictions, but not doing more than required in those jurisdictions,
Mhm.
then even a generally small task like doing an employee handbook can run into six figures nowadays, which is
Right.
awful. Yeah, it's really tough.
It is, and we we talked about kind of the employee handbook, and a part of that is really communicating an employer communicating the policies to really help the employee understand, what is necessary with these steps here. Um, it's almost a preemptive strategy to make it extremely clear as to what they need to do or what is required for these two different types of laws. So, how can employers effectively communicate leave policies to ensure understanding and compliance among their workers just overall?
First, I would definitely recommend they have written policies. And again, under the FMLA, there are certain written notices that must be given, uh, or there may be problems for that employer. So, by all means, do that. The employer policy can be customized under the FMLA, but it has to include at least the information that's in the government templates. And those are all available on the US Department of Labor website. So that's FMLA. For ADA, I would normally recommend that an employer have a reasonable accommodation policy of some sort. Um, and it needs to cover not only ADA disability related accommodations, but pregnancy related accommodations and also religious accommodations, which is also a requirement under federal law. So, and as far as that's concerned, I think employees just need to know it's available. Here's who you contact if you need
Mhm.
an accommodation or think you may need an accommodation. And, I think it's nice to have a statement also just saying we accommodate our employees who need accommodations, but even that part may not even be necessary. But just let people know where to go. And these are the categories of accommodations
Mhm.
that we are willing to make. And there may be other ones that apply under applicable state law again. Um, the ADA, unlike the FMLA, has no formal written notices the government requires employers to give. So I think just that reasonable accommodation policy in the handbook, or, you know,
Mhm.
by handbook, I also mean intranet, whatever
Right.
the company is using. Um, and then the next thing I think employers need to do is make sure uh, their non HR people understand at least the basics of these laws and
Mhm.
understand generally that there is a requirement to accommodate in these circumstances. Just so, because let's say you have a supervisor who says, no, we don't if you can't do this job 100%, we're going to put you out on a medical leave. Well, that's a supervisor, and the company's already going to be liable for that.
Right.
So, supervisors and managers who are not in HR need to at least have a basic understanding of
Mhm.
what the company's obligations are and know who to contact if an employee comes to them and says, I need a reasonable accommodation. They need to know
Mhm.
where to send them. And then, of course, HR needs to be the experts on it.
And, like, we talked about all these different layers that come with, like you said, like, just more surrounding, religions and, people who are pregnant at work. There's just a lot of layers to this, and education and clear communication is really key. I love that you said, for the non-HR professionals in the workplace, just educating, simply understanding the basics is essential to that clear communication so that there's consistent messaging, right?
Right. Absolutely.
And like we talked about with those layers, there are some common legal pitfalls employers should be aware of. And from your employment law perspective, what are some of those pitfalls that employers really should be, just watching out for and making sure that they themselves are complying?
Great question. And there's one, in my opinion, and it's a very bad pitfall. Um, a lot of employers think that once they have met their FMLA obligation or they've determined that the FMLA doesn't apply, maybe the person hasn't been working there long enough to qualify. Uh, a lot of times they think they're done. And I've seen this in a number of real world cases. Unfortunately, they forget about the ADA, which may still be there. And so, let's say you have an employee who's only worked for you a couple of months, and they have a devastating medical issue and need to be out of work. And the employer's answer is, well, sorry, you haven't been working here for 12 months. So you're not entitled to FMLA leave. So there's nothing we can do. We'll go ahead and terminate your employment. You can't do that. So that is the biggest thing I see, that people just completely forget that the ADA is even in the picture. Um, and both can be in the picture at the same time, or one or the other.
Wow. And it's circling back to that education aspect because without the full understanding that, the ADA might apply in that situation, with that lack of education, that's where the mistake can happen, right?
Right.
Wow. It's really insightful, and something for a lot of people to really absorb. Just kind of sit there, think about it. Maybe ask your company what resources you may have for sharing that message and educating each other. Is that something you'd recommend?
That's probably something I would definitely recommend that HR have down. If employees know where to go
Hmm.
and their non-HR supervision know where to go, that should take care of most of it as long as the HR people know what's going on.
Right, right. That makes sense, and that's why conversations like this are so important to kind of spread that awareness, create that awareness, so that if it's not clearly implemented into the HR program or clearly communicated in consistent messaging in the HR program, that HR program needs to kind of relook at their strategy here,
Yeah.
and you know for a lot of employees, returning back to work, that's another challenge from extended leave. It's not an easy thing to do, and it can be a little, tricky because everybody is different. Everybody's situation is different, and how they handle it coming back to work and transitioning is also extremely different. So, what steps can HR professionals take to ensure that really smooth transition as best they can, at least to show that the employee has support so that, everybody's kind of on the same page.
Yeah, and that's a really good question too. One thing I would recommend is that the employer make sure, if somebody's been out on an extended medical leave, make sure their training and their skills and all of that
Mhm.
is up to date. And if not, give them a reasonable opportunity to get back up to speed on what's been going on while they've been out. I think even soft things like giving them a chance to get reacquainted with their coworkers or meet new people who were hired while they were out on leave is a really important thing for employers to do. So I would do that. And also, I think employers need to be aware that even though this person is back from their major leave, they may still need intermittent leave to go to doctor's
Mhm.
appointments and other things like that, physical therapy, whatever, depending on their situation. So that may still be coming into play. Um, and the last thing I would recommend is, the employer ought to just somehow convey to this person who's been out on leave, we are happy that you're back. And I don't know if that means a welcome back lunch or, something that small,
Mhm.
but I think it's good to let people know you're happy that they're back from their
Right.
leave.
And that kinda goes for all types of leave, even maternity leave. I feel like, we had a coworker, she came back from maternity leave. We were so excited to have her back, not only just because she's so good at her job, but, and we were grateful for her. But she just really brought sunlight to our team. So I remember we went out and we made sure we got her a little something to say, "Welcome back. We're so excited to have you." And I think it just helped, especially with, a new mom. It's a whole
Oh,
world of a
yeah.
difference. And I'm sure that's something you've seen with a lot of employers, hopefully that they try to do. It's a little thing, but it can go far for the employee going through that maybe somewhat difficult transition, right?
Yeah. Yes.
So, in your experience, with people coming to you after having certain issues, have you seen kind of just this area where maybe they lacked to have a successful leave coordination that may have caused that problem, where they ended up coming to you?
For the most part, it has been the issue I referred to where the employer worries only about the FMLA, maybe workers' comp, if that's
Mhm.
involved too. I forgot to mention workers' comp. So they may have those two parts nailed down and completely forget about the ADA.
So essentially cover all your bases.
That's right. And
Yeah.
don't forget the ADA.
Mhm.
Usually people remember the FMLA and they remember workers' comp if that applies at all.
Mhm.
Um, the ADA is the one that slips through the cracks, in my experience at least.
Right. I know not everybody in our audience might be a sports person, but, covering all your bases, I just think of baseball. It's possible, someone might steal home. You just gotta be and it's almost like your head's on a swivel trying to pay attention to all these things. It can cause some stress, I'm sure. But that's why, your expertise, people coming to you, even just, for insight or consultation might even be smart, to do that type of work.
Yeah, they pretty much have to. And I do think it's unfortunate this has all become so complicated.
Mhm.
And I've thought about whether, is there something Congress could do to simplify this? Not take away any rights from employees, but just make it easier for employers with good intentions to do what they're supposed to do. It's tough.
It definitely is tough. I understand because we've talked about those layers, we talked about the complexity, um, and I think it's because, there's just so many different types of scenarios and people and, industries and just requirements, so it's great for everybody to feel educated on this topic. Um, I'm gonna ask one last question really here because this is what we do at the end of every podcast is we ask this personal question because you've come so far in your career here in employment law. If you could go back to your younger self, knowing what you know today and how you become so successful in your position today, what is the one piece of advice you would tell yourself to, help in your success to get where you are now? Even if it's just a little personal or just something to do with the actual job.
I think when I started out, I was very adversarial
Mhm.
and very unsympathetic to employees who were having problems and plaintiffs also. Um, Probably a little too much of a litigation mentality.
Mhm.
Uh, And so, yeah, if I had to do it over again, and over the years, I've really changed where that's concerned. And I do have a lot of sympathy a lot of times for employees' situations. And I think a lot of that has been what I've learned from working with HR people, to tell you the truth. They've been a good influence on me. But yeah, so if I had it to do all over again, I think I would have started out, um, you know, viewing employees less as adversaries and more as human beings with their own needs, and often very legitimate needs.
Exactly. We at SHRM, we say the phrase, exercise your empathy muscle. That's what our own president and CEO, Johnny C. Taylor Jr., has said in multiple of his speaking engagements. And that's always stuck with me. And I hope it sticks with our audiences as well. And exactly from what you were saying, if you could go back in time, you tell yourself to do that as well. And I
Yeah.
think that's a really great piece of advice. I think a lot of us can relate to that. I wish I did something different when I went back in time, if I could go back in time. So it's always a great question, especially for anybody who is emerging in their career right now, who is watching and listening. So that would be great. Thank you so much, Robin. We appreciate your insight. That is going to be it for this week's episode of All Things Work. Thank you so much for providing your expertise and breaking down these two very complex laws.
Oh, my pleasure. I appreciate your having me.
This is a critical impact on the workplace, so it's an essential topic. And before we say goodbye, I encourage everyone to follow All Things Work wherever you enjoy your podcasts. Also, audience reviews have a really big impact, so please follow us on social media, comment, like. We'd love to hear your thoughts as well. And you can find all of our episodes on the SHRM website, shrm.org/allthingswork. Thank you for joining us, and we'll catch you next week.